Let's move on, and I'll turn this over to Jordan to discuss initially state law regulations.
Thanks, Andrew. Since there is no comprehensive federal drug testing law, for the most part, for private employers, this leaves the field open to state regulation. Typically, employers have the right to test for drugs, either during employment or pre-employment, unless there is a restriction pursuant to state law. However, there is still a continually developing body of law on employee privacy issues and many other relevant issues that we'll be discussing later that could impact this general rule and make it be that programs that are not explicitly authorized open and susceptible to legal challenge. And that is really what we're going to discuss for the next few minutes here. Many states have enacted some type of drug testing restrictions. For example, some states limit drug testing to employees that they think have that the company is reasonably suspicious that they have a drug problem, or that there is probable cause to assume or conclude that this person is taking drugs. Other states impose restrictions only on public sector employees, but not on private companies. Other states only authorize drug testing for employees in safety-sensitive positions. And even other states explicitly authorize random testing under specific certain circumstances. So there's really no way we could go through every single state law and tell you what they do and if they mandate specific methods for handling drug tests and how they mandate them. But suffice it to say that these are all some restrictions that states have, while other states have no restrictions whatsoever. However, even if your state has no restrictions on drug testing, that doesn't give you, your company, carte blanche in terms of how you can drug test and whether or not you drug test. Essentially, there are a whole plethora of legal concerns that you need to be aware of, even if you know as a fact that your state allows you as a private employer to engage in drug testing. Essentially, employees and or applicants may have legal claims based on who was tested, how the test was conducted, or even how the results were used or if they were disseminated to others. One of these ways that your company could face exposure is through a violation of state procedures or state laws. For example, in Maryland, this is one of the factors I listed on the previous page, an employee can bring a legal challenge against an employer who did not have a legitimate business reason to test or did not provide documents that were provided following a positive drug test. So whichever state you're located in, you need to know the specific rules so that you make sure your company does not run afoul of those rules. Also, general discrimination claims. An employer who, for some reason, singles out a certain group of employees for drug testing, say by race, by age, possibly by gender, or any other protected characteristic, could face a claim for discrimination and or having the drug testing policy be discriminatory. I did not even mention disability discrimination there because that's a whole separate factor that we will be discussing in much greater detail later. In addition to discrimination and violation of specific state procedures, there's also a potential for an invasion of privacy claim. Even an employer that is allowed or required to test for drugs could violate employee privacy in the way it actually conducts the drug test. For example, if you require an employee to provide a urine sample in front of others or disrobe in front of others or something to that effect, you could face liability for invasion of privacy. Finally, an employee could even have a claim for defamation if, for some reason, you as the employer publicize an employee's positive test result, especially if the employer has reason to know that the test might not be accurate. You know, one of the factors for defamation is that you publish a statement and you know it's false. So that could happen if a first test was positive and then a retest showed a negative result, but for some reason the employer still decided to reveal the results of the first false positive. As I said, there's people from all over the country on this webinar, so we can't go into specifics about each state in which you are located. We'd be happy to do so and answer individual questions at another time. But for now, I did want to talk about specifically drug testing in D.C., and Andrew will provide in detail the requirements of California law, which are much greater than D.C. Currently, D.C. law does not address drug testing in private employment other than for companies that may contract with the District of Columbia. Stated another way, drug testing is not prohibited or restricted, but you still have to make sure you do not violate any of the legal provisions that I just discussed about: invasion of privacy, discrimination, defamation, etc. Basically, though, in D.C., if you at all work for an employer who contracts with the federal government, there is a good chance your company will need to establish a drug and alcohol policy. So really be on the lookout for any type of interaction with the government, because then all those rules that Andrew discussed with the Drug-Free Workplace Act may apply. Similarly, private employers in D.C. that are in any way licensed by the government or who provide employees with work and safety-sensitive positions having anything to do with the government must establish mandatory drug and alcohol testing policies. In some situations there, an applicant may be offered employment contingent on the receipt of a satisfactory drug test result and could work in a position that is not safety sensitive before receiving the results of the drug test. Also, I don't know if we have any specific D.C. government employers on the line here, but just know that employees of the D.C. government can randomly be selected for drug and alcohol testing. Another concern similar to what I mentioned earlier in the invasion of privacy has come out in Massachusetts. So I just wanted you all to be aware of this situation, either if you're located in Massachusetts or just in case this type of analysis gains more traction and becomes relevant in other states. Essentially, Massachusetts legislation, like many other states, does not address drug testing in private employment, so it is lawful. However, the Supreme Court in Massachusetts recently issued a ruling on random drug testing in private employment. In that case, the court found that the validity of an employer's random drug testing policy needs to be weighed on a case-by-case basis and must take into account the employee's job responsibilities against the employer's interests. Specifically, the court found that a random drug test policy was valid as it applied to one person. That employee drove up to 25 miles per year for the employer and thus posed a health and safety risk. However, the court found that the random drug test was not valid as applied to a different employee, someone who was a technical editor whose job did not involve national security and did not pose an immediate risk to health and safety. For that individual, the court found that the employee's right to privacy outweighed the employer's interest in drug testing. So these are just the issues that you need to be aware of. I don't want to discourage you from testing for drugs if that is something that your organization does, but you just need to be careful and cognizant of these different competing legal interests. With that, I'm going to turn it over to Andrew to talk specifically about drug testing in California.
All right. So in California, our state is so unique in many different ways to the chagrin of employers, and one of those areas is drug testing. California does have specific guidelines for drug testing, and I say guidelines, but there's really nothing all that clear about them. Basically, the authority for the regulation of drug testing in California stems from the California constitutional right of privacy, which is a heightened privacy right in California. And there have been a number of court decisions that have interpreted that right as it applies to drug testing. These decisions, many of them date back quite some time. I would say in the last 10 years I haven't seen much change in the law. But as employment lawyers, we're constantly reading between the lines and advising clients on what we think is permissible. I'll start with the first category of testing, that is applicant testing. And that's the clearest in California and in many ways the least risky. Employers may require that applicants for employment undergo drug testing, testing for illegal drugs. And the testing can be required after an offer of employment has been made and before employment actually begins. That testing must be administered across the board to all employees within that particular category. And the courts have upheld this sort of applicant testing as long as employers test all applicants for the particular job positions and not single out applicants based on any protected characteristic. So it's very important that this be a uniform applicant testing required for either the entire workforce or certain categories of employees. If there is a decision made in California not to test all employees, that's something that will have to be carefully considered, ideally in consultation with counsel given the risks involved. Now, moving to another category of testing, which is post-accident testing. This is reserved for safety-sensitive positions. There was a California appellate decision that addressed this issue, and the authority essentially allows testing where there is an accident, and it would be an automatic requirement for drug testing. And safety-sensitive positions are essentially positions where there is a hazard unique to the position. It really is a case-by-case evaluation to determine whether it's a safety-sensitive position. You're typically thinking about positions where it can be, for example, in a manufacturing setting where there is an immediate risk of physical harm or severe property damage or otherwise by the nature of the work that's being performed. An office position, for example, would not by any stretch of the imagination be a safety-sensitive position. I'm sure we could think of some scenario, though. And the post-accident testing it's given after there's a fatality or a serious accident. It's really important, as with any type of drug testing, that there be a clearly delineated policy explaining how this testing operates when it comes into play. If there is a serious injury, a fatality, serious property damage, those are situations that could conceivably trigger a post-accident testing requirement. Another important requirement for post-accident testing is that the testing be conducted in the least intrusive manner available under current circumstances. So, for example, many cases have upheld a urinalysis as a proper testing procedure since it's less intrusive than other sorts of testing, such as blood testing, and that's something important to consider in implementing the testing requirement, the testing program. There was one California court decision that did discuss random testing, and it's analogous to the post-accident testing situation. And the key requirements were that the program be announced substantially before its implementation, that employees receive counseling or treatment without fear of reprisal before the policy is implemented, and that it apply only to safety-sensitive positions, as we discussed. Now, addressing the remaining categories of drug testing, there's random testing, and we indicate below that it's controversial. Random testing is problematic, very risky for employers in California. And there has been one decision, at least in California, a significant one, that has upheld it, but in very limited situation involving a safety-sensitive position. And if you're considering random testing, you'll want to very carefully develop the policy. A preferred approach would be to adopt a post-accident testing requirement instead. The last category for drug testing is reasonable suspicion testing. This has been uniformly upheld by the courts in California. This is testing that is based on a reasonable suspicion that an employee is using drugs. And that reasonable suspicion can be based on a number of factors, including direct observation by a supervisor, information provided by a reliable source that the employee is using drugs. Now, although an employer can very clearly develop a reasonable suspicion testing policy that would pass muster, it is a very difficult testing process to apply. It's who's to say that any of us truly know what are the telltale signs of drug abuse, depending on the type of illegal drug that's being used. There oftentimes can be a number of explanations for why this employee may have erratic behavior or other behavior that might suggest drug abuse. And so over the years, I have not seen many situations where an employer can clearly apply a reasonable suspicion testing to a given situation at work. In California, there's also some other considerations in the drug testing realm. It's important to note that there is a statute, a law in California that requires employers with 25 or more employees to reasonably accommodate any employee who volunteers to enter an alcohol or drug rehabilitation program. That should be a policy that employers doing business in California have. There's also a California Drug-Free Workplace Act that applies to employers that contract or receive grants from the state of California. There's certain certification requirements. There's some similarities to the U.S. Drug-Free Workplace Act. And there's other areas of potential liability. Jordan touched on them. There's potential defamation claims. There's also wrongful termination claims for employees that were discharged for testing positive, perhaps falsely, or for refusing to submit to drug testing that would be deemed unlawful. And there's also discrimination claims that can be asserted under the California Fair Employment and Housing Act, specifically claims relating to disability discrimination comparable to that which you would see under the Americans with Disabilities Act. Other considerations, too, are the testing process, and I was addressing specifically the types of testing, but another very important consideration is to look at how the testing is actually administered. It is important to ensure that there's a chain of custody, that the testing sample is essentially locked away and preserved until it's actually tested, and that there's a minimized intrusiveness in how the testing is actually applied. Now, In San Francisco has its own drug testing law. It's unique in that way. You have this beautiful picture of the Golden Gate Bridge. You almost forget how difficult it is to do business in San Francisco with this beautiful picture here. But the San Francisco has a law that is very restrictive, and so companies doing business in San Francisco need to keep that in mind in applying their drug testing policies. Essentially, in San Francisco, an employer cannot conduct drug testing except where the employer has reasonable grounds to believe the employee's faculties are impaired on the job. The impairment must present clear and present danger, and the employee must have the opportunity to rebut the testing by a state licensed facility. So if the employee disagrees with the testing results, the employee must have the opportunity to submit to alternative testing. What does this mean in San Francisco? This means that an employer cannot conduct applicant testing across the board. It does suggest that there might be situations in a post-accident where an employer would be able to conduct drug testing if it meets these requirements. Over the years, I've seen very few San Francisco employers conducting drug testing as a result of this law. There are also labor relations implications in drug testing, and that's important to note. Any of you that have a collective bargaining agreement with a union, it's important to review that agreement to make sure that there's no provision that restricts your ability to conduct drug testing. And if there is a restriction, then you'll need to bargain with the union and reach agreement before implementing that testing program. If there is no provision restricting your ability to conduct drug testing, it's important to bargain. You have a duty to bargain with the union before implementing any policy. A failure to institute bargaining before implementation could result in an unfair labor practice charge with the NLRB, National Labor Relations Board. Now let's move into the one federal law that's critical here and that overlaps to some degree, and that's the Americans with Disabilities Act. That's the statute governing disability discrimination in the workplace. Now, the ADA does not generally regulate drug testing because the use of illegal drugs is not considered a disability under the ADA. However, there are different situations where drug testing can implicate concerns under the ADA, specifically where there is prescription drug use or an obligation to reasonably accommodate. And let's start with prescription drugs. Now, when an employer tests for drug use, if there is a prescription medication that's identified from that testing, that prescription medication cannot, well, first of all, that prescription medication cannot be specifically tested unless it is job-related and consistent with business necessity. And that's a standard that's required, or that the EEOC has concluded is required any time you conduct a medical exam, and it would be essentially considered a medical exam in this circumstance. If an employee is fired or an applicant is denied a position because of a positive drug test, and that drug test results from or shows that there were legally prescribed medications, the employer can be liable. What does this all mean? It's important that the drug test be reviewed by a medical review officer who determines that if there is prescription medication use, that such use is legal. It is problematic for an employer to conduct itself a further inquiry into that prescription medical use. And ideally, the employer should have a positive or negative, very limited test result. If the employer concludes that there is prescription drug use and it's a safety-sensitive position, then that may be a situation where the employer needs, as part of a medical evaluation, which is a whole separate inquiry, to determine whether the employer can safely perform the essential job functions of his or her own position with or without a reasonable accommodation. If it's not a safety-sensitive position, there would be no need for the employer to conduct an individualized assessment regarding that prescription drug use. Another consideration under the ADA is the obligation to provide a reasonable accommodation. As many of you know, the ADA requires that employers provide a reasonable accommodation for any employee with a disability. And that accommodation can take a variety of forms, and typically it can be providing employee leave of absence, modifying a job, and other workplace accommodations. This comes into play in the drug testing environment in the limited capacity of how the drug testing is administered and any request that's made by the employee in that context. It's important to note, too, that the requirement for reasonable accommodation of the ADA may be found also in various state laws that are patterned to some degree after the ADA. So an employee, just to recap here, an employee is required to reasonably accommodate employees and applicants for employment. An employer must make reasonable accommodations to allow the individual with a disability to perform the job. And there is an exception for undue hardship, which has a very limited application. And the employer must include accommodations that may relate to the pre-employment drug testing process. There are a number of lawsuits that have been recently filed by the Equal Employment Opportunity Commission, the federal agency that oversees the national civil rights laws, and that would include the Americans with Disabilities Act. The Baltimore division of the EEOC has filed two lawsuits, one against Kmart and the other against Walmart. And in the Kmart lawsuit, an employee or an applicant for employment was offered a customer service position, and the applicant indicated that he could not provide a urine sample because he had kidney disease and was undergoing dialysis, and that somehow affected his ability to provide that sample. The employee did offer to provide another type of sample, whether it be hair or a blood test. Kmart denied this requested accommodation and insisted that all new hires complete the standard urine test provided at its facility. EEOC filed a lawsuit and ultimately obtained a significant settlement of approximately $100,000 from Kmart, and an agreement by Kmart to revise its alcohol and drug testing policy and institute other changes. So what this decision brings home, and no one wants to be the kind of poster child of the EEOC, any lawsuit filed by the EEOC and any settlement is publicized on their website. And so the really important point here is, as I mentioned earlier, is to consider less intrusive means of conducting the testing where available. And this was one that could arguably be done with no additional expense. The other lawsuit by the EEOC was against Walmart. It's a very similar issue. It was a applicant for a sales job, and that applicant was required to undergo drug testing, and the applicant had end-stage renal cancer, which prevented her from taking a urine test. That employee asked for an accommodation to take an alternative test. That request was denied. As a result, the EEOC sued Walmart for violating the ADA, and there was a settlement, a pretty sizable settlement with the EEOC, and Walmart agreed to provide 90 minutes of hiring manager training on the accommodation process and to post a notice to all store employees. So the lesson from these two lawsuits is to ensure that there is a process in place to consider accommodations. If there's an employee that for some reason cannot comply with the normal drug testing process that's in place. And now I'll turn it over to Jordan to discuss marijuana laws.
Thanks, Andrew. Now we turn to marijuana laws, which is a really exciting area of the law because it's changing almost every day. And when the laws change, courts have something to say about it, and different courts analyze things differently, and it really is becoming a perplexing issue for employers, but nonetheless a very important issue. So hopefully we can clarify some of the most confusing scenarios in the next few minutes here. So far, 23 states and D.C. have legalized marijuana use for something, either be it recreational or certain medical conditions. I have the list here of all states along the right-hand side of the slide. So if you are one of these states, you really need to be cognizant of what's going on. And there are 4 states, Colorado, Washington, Oregon, and just recently Alaska, as well as D.C., that has legalized marijuana use for individuals who are 20 years of age or older. As I said, these state statutes are really new, and for that reason, most have not yet had an opportunity for judicial interpretation. What that means is there's very little guidance, essentially, about what the statutes mean, much less a clear direction for employers that are trying to grapple with how their employment policies and practices should be modified to take into account these statutes. And a big reason for this uncertainty is that federal law continues to prohibit marijuana use. So it's seemingly at odds with the state law that is allowing marijuana use. And it's this dichotomy that's really causing most of the issues here. Just real quickly, in most marijuana statutes, states allow access to medical marijuana through a registration or some type of identification card. These statutes typically permit patients to seek physician authorization to obtain and use the marijuana for medicinal purposes. And these cards are typically valid for 1 year. Notably, some states prohibit discrimination against individuals on the basis of their being a medical marijuana registration or card holder. This is the case, however, even though these same states may permit employers to terminate or discipline employees for marijuana use. And I'm going to talk about one specific state in a few minutes that there's a lawsuit on this very issue. But essentially, the crux of what we're trying to get at here, and what I think a lot of employers on this webinar want to know, is whether, as an employer, you may lawfully impose discipline, including termination, suspension, or any other form of discipline, to an employee who tests positive for marijuana. And the answer varies somewhat depending on the state where you are located. Generally, you have the right to discipline almost in every state for marijuana use on employer premises or where the employee is intoxicated on the job. That's even in the 4 states I mentioned, in Colorado, in Washington, D.C., in Oregon, in Alaska. If an employer is smoking marijuana on company premises or if he's being impaired while performing his job, you have the right to impose lawful discipline. However, the case law, while there's mostly case law supporting the employer's right to terminate an employee when an employee tests positive for drugs, or including marijuana, that is where some of the complicated issues arise. So stated another way, we're trying to figure out whether an employer can discipline an employee for off hours and off-site use or influence, either when it's pursuant to a valid description or just for off hours or off-site recreational use in states that may permit recreational use. And there are some answers to those questions, but they are not totally clear. As I mentioned, some states, Rhode Island, Arizona, Delaware, Minnesota, they have statutes that expressly prohibit employers from firing an employee for a positive marijuana drug test if that employee holds a valid marijuana card. By contrast, some other states, I think California, Montana, Oregon, even Washington, there exist statutes or case law that direct employers to be able to lawfully implement a zero-tolerance drug use policy regardless of the legality of marijuana use under state law. It's almost similar to a free speech analysis under the Constitution. You know, you are not allowed to be prosecuted by the government for something that you say. However, at work, your employer can take an action based on something you say if it reflects poorly on the company. And that is similar to what's going on here. In California and Oregon, you know, there are cases saying an employer can take any actions it deems necessary. That being said, as marijuana laws evolve and expand, these laws could be reconsidered, as some of these cases are 2, 3, 4 years old, which is just a lifetime in this type of ever and fast-changing area of the law. So employers who take action against employees with positive drug tests can run into issues with statutes that prohibit employers from taking adverse actions for what's known as lawful off-duty activities. In those states, therefore, an employee who tests positive for marijuana can potentially claim that he is protected from termination so long as his use of the drug occurred during non-working hours. It's interesting, typically these types of lawful off-duty statutes were aimed at protecting employees' right to free speech, so they could not be fired really for engaging in political activities or picketing or doing some other activities that their employers happen to disagree with. However, these statutes do apply to personal and lifestyle decisions. So if there is a lawful off-duty statute in the state in which your company is located, you as an employer really need to be careful about penalizing employees for their off-duty marijuana use. And essentially this all comes down to a pending case in the Colorado Supreme Court right now entitled Coates versus Dish Network. I'm just going to spend a few minutes on telling you about the facts of this case, as this is really the leading and seminal case in this area. And although right now it's only in Colorado, it may end up being applied to states, at least all states with recreational marijuana use, if not more. Essentially, the plaintiff, Brandon Coates, he was paralyzed in a car accident when he was a teenager, and as a result was a licensed medical marijuana user. He continued to be a licensed user at the time he was working for Dish Network at their call center. At some point, the company required him to take a drug test, which he failed. As a result, Dish Network terminated his employment based on its zero-tolerance policy, saying, if you test positive, we will terminate. Coates brought an action for wrongful termination under Colorado's Lawful Activities Law, which, as I mentioned, it prohibits you as an employer from firing employees for engaging in legal activities while not at work. As a plaintiff, Coates claims that his position was not hazardous, he was not in a position that required extensive decision-making, and most importantly, he was never under the influence of the drug during work time or on company premises. He also claimed, interestingly, that Dish Network knew of his status as a medical marijuana patient when he was hired, making their claims of a zero-tolerance policy invalid. Dish Network, on the other hand, asserts that it's lawfully entitled to enforce its policy, and in any event, although marijuana is explicitly legal under state law, marijuana usage is illegal under federal law. That's the dichotomy I was talking about previously. So far, the Colorado Trial Court and the Colorado Court of Appeals have ruled for Dish Network and found that its termination decision was lawful. However, that's not so relevant at this point because the Colorado Supreme Court has granted cert, and in October it heard arguments on the case. And a decision is expected any day, and experts are really split as to whether it will come out for the employer or for the employee. Which, however it comes out, the outcome will be very significant for employers in all states. Given that Colorado has been at the liberal forefront of legalizing marijuana, if the Colorado Supreme Court affirms the ruling in favor of the employer, it will certainly strengthen employer rights in all states to terminate employment and otherwise discipline employees who fail drug tests as a result of any marijuana use, regardless of the legality of that drug's use under state law. And similarly, it will allow employers to continue to enforce zero-tolerance policies. However, a ruling for the employee would completely nullify that and would lead to essentially further confusion for employers around the country, and employers would really need to reassess blanket bans on marijuana use and may need to revise their policies relating to prescription drug use more generally. So all eyes are keeping a lookout for this case, and it is really something to be aware of, again, even if you're not in Colorado. I also want to talk specifically about Washington, D.C. trends regarding marijuana use. As I mentioned earlier, Washington, D.C. is now the 5th jurisdiction to approve a law legalizing recreational marijuana. So the new law permits individuals to use marijuana on their personal time, but it does not permit employees to use marijuana in the workplace, and it does not create any additional protections for employees while they are at work. So, again, this is similar to the free speech issue that I brought up a few minutes ago. So for now, D.C. employers are free to promulgate and enforce any rules prohibiting employees from bringing marijuana with them to their place of work or being under the influence of marijuana while at work. D.C. employers also are free to enforce whatever policies they have, like a zero-tolerance policy, and could therefore lawfully terminate any employee who tests positive for marijuana pursuant to a valid drug test. Interestingly, though, the D.C. Council has just passed temporary emergency legislation which bans what's called arbitrary pre-employment drug testing. The bill is called the Prohibition of Pre-Employment Marijuana Testing Emergency Act of 2014, and it explicitly states that an employer cannot test a potential employee for marijuana use until after an offer of employment has been made. So you really need, if you test applicants for this, you really need to be aware of this law, as again, it prohibits you as an employer from testing from applicants and or potential employees before making a conditional job offer. That being said, once you make a conditional job offer, you are then allowed to require drug testing. Once the applicant becomes an employee, he or she must then adhere to workplace policies set forth, which could include a zero-tolerance policy. So again, this is temporary emergency legislation that's in effect for approximately the next 6 months. Interestingly, there is now discussion in the D.C. City Council about a potential law that would go further than this law. That potential law is called the Prohibition of Pre-Employment Marijuana Testing Act of 2015. And that would actually prohibit pre-hire marijuana testing altogether. So there wouldn't be any distinction between pre-offer and post-offer. The bill's been discussed at some hearings and is still pending before the D.C. Council. At this point, it's really unclear as to whether it will be passed. If it is, then D.C. would become the first jurisdiction in the entire country to impose an absolute ban on this type of pre-hire drug testing. But if I had to bet, I would bet this law would not be passed, but again, we will just have to wait and see. There's one interesting case I just want to discuss briefly, and I alluded to it in my discussion before. Rhode Island is one of those states that has a medical marijuana law which has specific anti-discrimination provisions. Under that law, employers may not refuse to employ or penalize a person solely for his or her status as a cardholder. So this is a different statute than just a lawful off-duty conduct statute or disability discrimination. This is an actual anti-discrimination law. And in this case, a plaintiff was about to receive an internship from a company, but after she disclosed that she suffered from migraines and used medical marijuana, the company told her that they were revoking the internship, even though she said she would not bring the drug with her onto the premises or show up for work after having taken the drug. So she filed suit, and this is the first suit to invoke the anti-discrimination provisions of such a law, and it really is a unique opportunity for the court to address head-on this type of anti-discrimination statute. And other states that have almost this exact same statute are Arizona, Delaware, Connecticut, Illinois, Maine, and Minnesota. And I know some people on this webinar have operations in some of those states. So employers with such operations really want to pay close attention to this case and see how it develops and really what the outcome will be both in Rhode Island and for these other similar states. I'm now going to turn it over to Andrew to talk about marijuana use in California and close with action items for employers to be aware of following this presentation.
All right, so in California, this is one area with marijuana use where there is actually clear guidance by the courts and favorable clear guidance for employers. There was a California Supreme Court decision by the name of Roth v. Raging Wire, in which the California Supreme Court considered the Compassionate Use Act, which essentially legalized, at least in California, medical marijuana use. And that medical marijuana use required that there be a physician's recommendation for the individual to use marijuana. Now, of course, just like the other states, this law conflicts with federal law. But the issue that was considered by the California Supreme Court in Raging Wire was whether an employer was required to essentially provide a reasonable accommodation or otherwise permit off-duty use of marijuana, given this California law. The California Supreme Court looked at the law and found that it was conspicuously silent on the issue of the employment relationship and whether the use of medical marijuana could somehow be a defense in the employment setting. The court concluded that that in this case, well, let me first explain that in this case, the plaintiff, the employee, was required to submit to pre-employment testing, and the testing came back positive for marijuana use, and it appears that the employee had indicated that that marijuana was being used to treat chronic pain. As a result of the test results, the employee was fired from his employment. The employee then filed a claim alleging discrimination under the California Fair Employment and Housing Act based on disability discrimination. The California Supreme Court came back and ruled that because the statute was silent on the employment setting and because medical marijuana use is not legal under federal law, that the medical marijuana use was not regulated in the employment setting, and that the employer properly or had the right to, in this case, require the testing and to terminate for a positive test result for marijuana use. So this is a very good decision for employers in California and allows employers to take an adverse employment action or termination decision based on marijuana use, regardless of whether that occurs outside of the workplace. At the end of this webinar, we will allow some time for questions, and there was one by Diane that I'll address on the subject at the very end. Well, let's move then to action items. Based on the issues we've covered, there are several considerations regardless of the state in which you do business or states. And one of them is developing a clear, coherent drug testing policy. And that testing policy should comply with the Americans with Disabilities Act, as well as any state law that might come into play. You'll want to first look at the type of testing you're developing, whether it be reasonable suspicion, pre-employment, post-accident, random testing, and ensure that those testing types are allowed under the applicable law. You also, regardless of the state in which you are doing business, you want to make sure that the testing is done in the least intrusive means possible to avoid any argument that you are infringing upon the privacy of your employees. And where feasible, you want to have consent forms that employees sign before they submit to testing at the time of the testing to show that essentially their agreement for the test results and knowledge of how that testing process will occur. You also want to have a consistent policy in responding to positive test results, whether it be by employees or applicants. Now, in terms of how this testing program is communicated to employees, you'll want to have a policy, ideally in your employee handbook, that informs employees of the types of tests they might be subjected to and the circumstances for that, and the actions that could be taken if they test positive. By placing all that information in the policy statement, you're essentially placing your employees on notice and diminishing their expectation of privacy, and that's very important here. And lastly, you want to train human resources and managers on on the drug testing policies and procedures. It's important that they understand the types of testing that can be conducted, the procedures, and very importantly, the disclosure requirements, and that to ensure that this information regarding the test results is not shared with any unauthorized party. The company could subject itself to a privacy claim or defamation claim based on the impermissible sharing of this information, say, for example, to coworkers. And in terms of the training, it's also reinforced from the Kmart and Walmart decisions that I was discussing earlier involving the EEOC, the importance of ensuring that that the managers in HR understand the obligation to reasonably accommodate if that were to come up, and otherwise the procedures, because one misstep at that level can present potential significant exposure. Now we're opening it up for questions, and I wanted to just go back to, there was a question by Diane who said, I don't care what my employees do on their off-duty hours. I do care if that off-duty conduct results in on-the-job impairment. Impairment due to marijuana is difficult to observe for purposes of a reasonable suspicion test recommendations. Now, Diane, I believe you operate in California, so I did want to address that question that ties into the discussion of the Raging Wire decision regarding medical marijuana use. Now, reasonable suspicion testing is problematic. It's very difficult to gauge what is a reasonable suspicion. In the Raging Wire decision, what occurred there was the employer was able to identify marijuana use through pre-employment testing. So for California, and this is very specific to California, the ideal means of testing would be pre-employment. Since you don't need any specific justification, you just need to ensure that this is being conducted across the board and that it's being conducted at the proper stage after an offer of employment is made and before employment starts. If you do that, you should be in the clear and you have the best argument for the testing. You could also conduct testing after an accident if it's a safety-sensitive position, but that, in a hospitality setting, office position, that would likely, in most situations, not be the case. Jordan, did you see any other questions?
Yeah, I saw one about in someone who is located in D.C. asked what happens if they test for marijuana and then the employee claims that they had used marijuana several weeks earlier, but the drug test, but it still showed up in their drug test several weeks after their use. And right now in D.C., it really doesn't matter when the employee used the drug or how long it's been out of the quote-unquote out of their system. D.C. employers are still permitted to decide how and when to take action and lawfully implement the zero tolerance policies. So long as your company is following some sort of policy that allows you to take disciplinary action against an employee for this type of drug use, you would be fine disciplining or otherwise terminating the employee for the fact that they test positive for marijuana.
And I saw one other question that was, it was asked whether an employer can test for alcohol use as well as illegal drug use. And that's a very good question. The EEOC takes the position that testing for alcohol use can only be done if it's job-related and consistent with business necessity, and essentially it would be treated as a medical examination. And so it would be very problematic to test for alcohol use unless there's a, perhaps it could be a safety-sensitive position, but I would advise not to test for alcohol use unless the employer has consulted with counsel and seriously considered the implications. The EEOC, or actually the ADA, considers alcoholism to be a disability, and that's the reason why there's a heightened standard for conducting alcohol-related testing. So absent any other questions, I wanted to thank everyone for attending today. We will be having webinars throughout the year, as Jordan mentioned. Also, we can make this webinar, the PowerPoint, available and the recording to anyone that would like it. Just send Jordan or me an email, and you have our information here on the slide, and we'll gladly forward that presentation, the materials, to you. Again, thank you for participating, and also if there's any follow-up questions that we weren't able to answer today, you can contact us directly regarding those.
Yes, from my perspective, thank you very much for attending, and please contact us with any questions. Thank you very much.